holding her down, pushing her, putting his hand over her mouth during repeated sexual assaults, told her he would kill her if she told anyone.
And there was a good argument for that, especially when we take into account that was your second sexual offense that you'd committed. It'd be a legally well-supported, for example, today to give you 3 or 4 years in prison.
What you just heard, that disturbing exposure by the prosecutor, is just the surface. What looks like a simple probation violation is actually a desperate attempt to bury a very dark, violent past. This is 19-year-old Ashton Moxlow facing the judge. On paper, it seems like a standard underage Dewey mistake. But why is his defense attorney trying so hard to paint him as a traumatized victim of the system? The narrative completely shatters when prosecutor Miss Good steps up and reveals the chilling truth: repeated, violent assaults against his own relative. Why does Ashton's tearful apology focus entirely on drinking, completely ignoring the helpless victim he terrified? With up to 5 hard years in state prison on the line, the stakes couldn't be higher. If you want to understand real courtroom psychology and watch how the justice system brutally dismantles a false narrative, hit subscribe. Let's dive into the case.
Okay, we can call next People v. Ashton Moxlow. This is file 23-6743FC for probation violation sentencing. Counsel, you want to state your appearances, please?
Prosecutor, Wayne County Prosecutor.
Liz Elliott on behalf of Ashton Moxlow, who sits at counsel table to my right.
All right. I have had a chance to review the probation violation report as well as an updated mitigation memorandum submitted by defense counsel. Ms. Elliott, have you had a chance to review the probation violation report with your client?
I have, Your Honor.
Any additions, corrections?
The only correction would be in terms of jail time. The original report anticipated a sentencing date of April 26th or 28th. I crossed it out.
Yeah, I've got 13 more days on that then, because it got adjourned till now then.
Okay.
Does that sound right?
Yes.
The other thing too is if we revoke his probation, as I understand it, the probation violation report gave him did not include the good time credits, but
That's
on
correct.
A probation violation, we would have to give him the good time credits, which would be an additional 60 days. So I had with that, if we were to revoke and commit, I've got him at 507 days that he'd be entitled to legally.
That's the number I reached.
Okay. All right. Any other additions, corrections?
No, Your Honor.
Any from the people?
No, Your Honor.
All right. Any allocution you wish to make, Ms. Allen?
Yes, Your Honor. Thank you. Your Honor, Mr. Moxlow wants you to know that he does have family support. They're watching on YouTube. They couldn't make the trip here. It's quite a distance for them. On the underlying offense, Mr. Moxlow was sentenced to a year in jail, was released on probation when this offense occurred. Up until the point that this offense occurred, he was fully compliant on probation. He was living with one set of grandparents. There were some family issues that came up that caused another family member to move into the house. So his probation agent said, "You can't be here." And within a matter of hours, Mr. Moxlow relocated to Frankfurt from Traverse City with his other set of grandparents. He got a new job. He was working on his high school diploma, and he had engaged in some counseling. So for all intents and purposes, he was doing well on probation when this offense occurred. Mr. Moxlow was 19 years old. He's young. The underlying offense occurred when he was 17 years old. He has a job waiting for him if this court decides to release him. Also, on the probation violation, it actually occurred in Benzie County. He pled guilty. He was sentenced on that file. He was given fines and costs and 12 months of probation. So in the event that this court decides to release Mr. Moxlow, he still has 12 months of probation ahead of him. So he has supervision if he's released. Our position, Your Honor, is that, you know, it's our job to make sure that there's not further offenses, and we send a message to the community. Mr. Moxlow's been in jail since December. He's got 507 days worth of credit. I would say that the consequence that Mr. Moxlow has had for the operating while intoxicated, he pled to an impaired, has been met. Okay, that will ensure that he doesn't come back before the court. So that goal has been met. The trauma of prison and that environment will only layer more trauma into Mr. Moxlow's life. And he's already, the mitigation report sets forth certain events that have taken place, and he's already got layers of trauma to work through, and that would just add several more layers to it. I don't know that would have him come out a better person than he stands today. He has a better chance of coming out better than he stands today with community supervision through Benzie County for the next 12 months to ensure that he remains a law-abiding citizen. One of the things that Mr. Moxlow has said to me is that he's very remorseful for his actions that bring him here. He understands that he should have and could have made a better choice that day. The mitigation memo talks about substance use. It's not even something that he's ever really had an issue with. This was kind of an isolated incident. He had a dispute where a long-term friendship ended. He was distraught and he didn't use the tools that he had, and he made a bad choice. He knows that now. He's done significant time in jail, and he's vowed that he will use the tools that he has and continue to work on himself so that he doesn't find himself in this position again. We're asking the court to follow the recommendation and give him credit for time served, discharge him as unsuccessful, and then allow him to serve his probationary term in Benzie County, get back to work, get back to his education, and get back to his therapy so that we don't see him in this court again. Thank you.
Thank you. Mr. Moxlow, it's not required you to say anything today, but you're welcome to. Is there anything you want to tell me or no?
Yes, Your Honor.
Go ahead.
First off, I want to apologize for showing back up in your courtroom, even though you gave me a chance and I screwed it up. Made a horrible decision to drink. I've sat here and realized, thought about what I did. I could have hurt myself, I could have hurt others. I have caused more stuff for my family to go through. And sitting in here this time, I've actually talked to other inmates and got their, their outlook on life and what they have done. And I don't want to see myself in their shoes down the road. There it is. I want to turn my life around. I want to keep going on the straight path that I've been going on. I want to continue my education, get my high school diploma, and hopefully enter a trade program, get a trade diploma. I thank you for your time, Your Honor.
All right, thank you.
Yes, sir.
Ms. Goodrich, any recommendations from the people?
Oh, yes, thank you, Your Honor. We're here on a probation violation. I think it's important to remember what originally led us to have him on probation. He was given a second chance after some pretty violent acts towards a relative that involved holding her down, pushing her, putting his hand over her mouth during repeated sexual assaults, told her he would kill her if she told anyone. In reading the mitigation memo, I didn't see anything addressing these violent acts that he did, these violent behaviors that he exhibited. It was, oh, he had a poor childhood, oh, maybe he has some mental health illnesses, but nothing related to addressing why he came to be on probation. It also kind of, made him sound like the victim. That I think even one line I noted said that his education was interrupted by the criminal justice system. Well, it was interrupted due to his decisions and his actions. He wasn't some passive victim where somebody came in and threw him in the criminal justice system. He was given a second chance due to his young age after all of that, and used that second chance at 19 years old to drink alcohol when he's clearly underage, to drive when he had no driver's license, and then to drink and drive. He was caught while speeding. He was 2 times the legal limit, and this was all while he was on felony probation for the second chance. I think that top of the guidelines at this point is appropriate at 24 months due to the public safety concerns of having Ashton in the community. Thank you.
All right, well, Mr. Moxlow, no, you're here today for a probation violation. The conduct that was the violation was the drinking and driving offense in Benzie County. But what that means then is we can go back and look at, okay, you didn't do real well on probation then by catching a new crime. And then you can be sentenced, on the original crime again, right? And when we were here for that original crime, that was, you got a fantastic outcome, I think, because you were 17 at the time of the offense. You were charged as an adult by the prosecutor, as was authorized by law, but you got a different outcome than, say, a 30-year-old would have gotten, right? It was a CSC offense. It was pled down to an attempted child abuse second degree with a 5-year statutory maximum. The guidelines, even at that reduction, were 12 to 24 months, which means even with that reduction, you stood at sentencing where a year in jail was the best you could hope for with probation. And you could have gone to prison that day. And there was a good argument for that, especially when we take into account that was your second sexual offense that you'd committed. One had occurred in the juvenile court system, and then a second offense that brought you into the adult court system. So then you get the probationary term, and then while you're on probation, you commit a new crime. It's very difficult to know what to do. I mean, your attorney has explained, a lot of good reasons why, why maybe we shouldn't send you to prison today. The prosecutor has given lots of good reasons why you should go to prison today. And frankly, your behavior on probation by committing a new crime would allow me to, that's not taken into account in those guidelines at 12 to 24 months. It'd be a legally well-supported, for example, today to give you 3 or 4 years in prison, and you get credit for almost 17 months. By my count, like 16, almost 17 months credit already at 507 days. And the prosecutor's not asking for me to exceed the guidelines. I really can't find any fault with what the prosecutor's arguing here today. And it's taking everything into account. It still is a fairly measured response to what has happened. So I think taking all those things into account, I'm going to revoke your probation, Mr. Moxlow. And on the charge of attempted child abuse in the second degree, I'm going to commit you to the Michigan Department of Corrections for not less than 2 years nor more than 5 years. I will give you credit for 507 days previously served, including the good time credits from the jail. The fines and costs that were previously assessed, I will reassess in any amounts that remain unpaid. That was $68 in state cost, $130 in crime victims. Those were paid off, right? Okay. There were supervision fees were unpaid, were not paid, but the fines and costs were paid in full. So we won't assess any, or we'll indicate that they have been paid in full on the judgment. All right, and that's within the advisory guidelines. I think it is proportionate to the circumstances of the offense and the offender, given the total information and the fact that it was a second sexual offense. So, Mr. Moxlow, that's the sentence of the court. If you wish to file an appeal, you can do so by filing an application to the Court of Appeals. If you want a lawyer appointed, you'd have to ask within 6 months. We're going to hand you a piece of paper explaining that process, ask you to initial one copy for us, so we have a record we gave it to you. The other one's for you to fill out if you wish to take an appeal. With the credit to which you're entitled, you'll probably end up doing about 7 months in there, okay? And then I presume, unless you misbehave in prison, you'll get paroled at your first bit and be supervised on parole. So good luck to you, Mr. Marks.
The judge made the final call. Ashton's probation was revoked, sending him to state prison. But here is the real debate. When balancing his young age against his repeated offenses, what is the true measure of justice? Comment below team prosecution or team defense. Who actually had the stronger argument today? If this outcome got you thinking, hit the like button. Share this with anyone who finds true crime psychology fascinating.